Day, 16th January 2025. The Honorable Caroli Omondi.
Thank you very much, Right Honorable Speaker, for this opportunity to speak on this NADCO report and the recommendations, which I note with a lot of gratitude that majority have been rejected. Because the first time I went through this report, I learned with horror that there was a proposal to increase the number of members of parliament so as to meet the 2/3 gender parity through further direct nominations. I firmly believe that we are a parliament of 290 elected leaders, 47 special seats by affirmative action, and 12 nominees. If you do your math, a third of the 290 would be somewhere around 87 plus. If you take away the 47, which are already affirmative seats, because you can't do affirmative action on seats that are already affirmative, and then you add to the 12 nominees, which I propose should be reserved to women, the shortfall would be something between 28-29. That being the case, since all our political parties get direct public funding, we should make it a requirement. If I was in that group, this is what I would have recommended. I should have recommended that every party, to qualify for public funding, must meet the 2/3 gender rule. Because they have safe seats which they can reserve to women in their strongholds. They have. And we don't have to add additional seats through party lists. Even the concept of party list itself is an oxymoron in our constitutional system. Party lists are used where parties are elected, not individuals are elected. In South Africa, ANC goes to elections. It is ANC that is voted for. No individual is voted for. In Kenya, we have direct election of members. So in South Africa, they have a party list. Those who will become MPs if they win a certain percentage of the vote as a political party. In Kenya, we don't need a party list. It is a constitutional oxymoron. So I'm very happy that this has been rejected. And my proposal is we do not need to work our heads too hard about the 2/3 gender rule. The solution is already in the Constitution.
The Honorable Caroli, what has been rejected?
I am reading the observations of the committee. They are clearly saying these things cannot be implemented. I've read.
From what I've read in the report, they are saying they're supporting it, they're only deferring its implementation.
It has been rejected. Read the observations of the committee. The proposal was overly ambitious and would pose significant implementation challenges.
That is the proposal.
Yes, during the current term.
Order.
Yeah.
Because it's good to debate so that Kenyans understand what you're saying, the information. Yes. In this report, and Honorable Mrugara, you can give us the page. The committee actually accepted
it is page 17.
The committee actually accepted that proposal. The only thing they're saying is overly ambitious is the proposal to implement it in this term of parliament. But in terms of the party list, the committee actually accepted that proposal.
Honorable Speaker, they are saying it was the committee's view that it would be neater to implement the proposal at the time of the current parliament. Yes. So anyway, whatever it is, the bottom line is, it is not workable. We already have a solution in the current constitution. All we need are about 87 fine ladies elected into this parliament, and 47 already have special seats. We have 12 reserved slots that we should reserve for women, whether they are PWD or workers or representatives. And then the parties, because of receiving political party funding, should be made accountable. It must be a condition that to qualify for political party funding, you must have enough women in your party. So I'm happy with whatever has been recommended here, but my understanding is that the nightmare...
I'll give you more time on this, Honorable Caroli.
Yes, please.
But I want you to read page 17, where you've referred me to, at paragraph 88.
Paragraph?
The same page, at paragraph 88.
The bill proposes to amend Articles 97, 98 of the Constitution. New clauses are inserted to provide that where after general election 2/3 principles is not met, the National Assembly and the Senate, this is where they'll fill them by nominations, yes, by party lists, which is an oxymoron. Speaker, you are a lawyer, you know. There's no concept of party list in our constitutional order.
The reason I'm holding you to this, Honorable Caroli, is that you are reading the report of the committee selectively, because the committee is saying in 88 and 89 that they agree with the report that the two-thirds gender rule be implemented through party list, if you read 88 and 89. What they are saying is overly ambitious in 92 is a proposal to implement it in this term. So the total sum of it is that we will still, if you are to go to the report, we will still have party lists that will have a top-up. That's what they are saying.
Mr. Speaker, thank you. So that I make progress on the other clauses, I will leave it here. It will suffer the same fate as BBI.
Correct. Allow him 3 more minutes.
It will suffer the same fate as BBI. Secondly, I'm very happy that this report clearly rejects the proposal to have leader of official opposition. Honorable Speaker, our constitutional architecture does not contemplate a position called the leader of opposition. If any leader of a political party wishes to lead his party in parliament, there's a pathway provided by the Constitution. They should nominate themselves, put themselves on the nomination roll, come into this house and be minority leader. Leaders of opposition, there is no way it can exist in our constitutional order. So again, we were taking people for a ride. I'm happy that is out. On political parties bill, I'm very happy that this report recommends that political parties cannot take away your election, as they have tried in the past with some of us. In Kenya, people are elected directly by the people, not by the parties. And parties are not elected in elections in Kenya. And once you are elected, even if you disagree with your party, they cannot remove you from this house. That is the law. They cannot remove you from this house. And let me put it very clearly. What we need to do is create what we call a crossbench in this house. If you go to the House of Commons today, the former leader of the Labour Party, the one who even ran for elections and lost, is no longer in the Labour Party. He's run as an independent. There's a crossbench which should be out there. Those who have not agreed with their parties or disagreed on issues and do not wish to caucus with their parties, there's a crossbench where they are free to sit. That is the practice in the Commonwealth. A political party cannot take away, they cannot overturn the will of the people after you've been elected. That is the law. But we should have gone further. They should have gone further and reviewed even Section 7, 2A and Section 7, 2, subsection 3 of the Political Parties Act, where dominant political parties are putting barriers to establishment of parties that can compete with them. And when we come to discussion of the new Political Parties Amendment Bill, which is also from NADCO and which has illegalities, we will point it out. There is no requirement that my party should have 1,000 members in 25 sub-counties. Or if I have a party, I should be registered in those sub-counties. If I want to form an OMENA party for OMENA fishermen, I should be allowed. And a political party should be registered in not more than 72 hours. That is a practice in the Commonwealth. Not what I'm seeing the games where dominant political parties are trying to create entry barriers to new competition in the political space. These are illegalities, and there are so many others. When I read this NADCO report, I see the time is running out. I may not exhaust all of them, but I'm very happy it is meeting the same fate as BBI. Because there were a lot of illegalities on this thing. Thank you, Mr. Speaker.
Well said. Thank you. The Honorable Otiende.
Thank you, Mr. Speaker. Mr. Speaker, I want to assure this House that this report was discussed